Protector, Advocate Kholega Talega, who is sitting next to the Public Protector, Advocate Busisiwe Mkhwebane, to whom I now hand over the reins to take us through the statement. Over to you, please.
Thank you, Mr. Sekhalwe, Program Director. Good morning to everyone. Acknowledging the Deputy Public Protector, the CEO, the Acting Chief Operating Officer, and the Chief of Staff, Executive Managers who are here, members of the media, ladies and gentlemen, good morning, and we apologize for the delay. Once again, let me thank you all for always honoring the invite. You play a pivotal role in bridging the information gap between this independent constitutional institution and the public it serves. As we often say, the public is constitutionally entitled to the contents of our investigation reports. Accordingly, this interaction serves to give effect to Section 182(5) of the Constitution of the Republic, read with Section 8 of the Public Protector Act. These provide that in the absence of exceptional circumstances requiring confidentiality, our investigation reports must be open to the public or any other person, including complainants and implicated parties in the matters concerned. The law leaves it to us to determine the manner in which we make this information public. We may choose to hold a media briefing, as is the case now, or we may use any other avenue we deem expedient in particular circumstances, including publishing the information on our website. Today, we will use both these avenues. Cumulatively, we are releasing findings in respect of 14 investigations that we have finalized since our last briefing session at the end of last month. However, for the purpose of this briefing, we will focus only half of those. Specifically, we will deal with the matters that have to do with basic education, infrastructure in Limpopo and KwaZulu-Natal, the plight of an Eastern Cape woman in respect of public housing challenges, and the conduct of one Western Cape municipality in relation to the investment of municipal funds. We will also deal with the alleged irregular appointment of a senior official at the Department of Correctional Services and one case involving the improper use of public finances in the procurement of goods and services. This and the rest of the other reports that we may not necessarily deal with in detail in this session will be accessible on our website shortly after the session. Copies will also be dispatched to parties in a while. For your information, those matters which we will not necessarily deal with in this statement involve Small Enterprise Development Agency and the Department of Trade, Industry and Competition, Solplaki and Karieberg local municipalities in the Northern Cape, Masilonyana local municipality in the Free State, Department of Mineral Resources, the South African Social Security Agency, and the Northwest Transport Investment, it's a SOC Ltd. These are important reports which we implore you to have a look at and help us educate the public about our work while also vindicating rights and holding organs and functionaries of state accountable. They cover themes such as the prejudice that the public often suffers at the hands of public servants, occupation and leasing of land, failure to register staff as members of provident funds and pay their contributions, mining rights and corruption. This brief comes just 2 weeks after we launched the Public Protector Stakeholder Roadshow. The Roadshow is our flagship outreach program during which we interact with parties who have a keen interest on our work in fulfilling our constitutional mandate to investigate, report on, and remedy alleged or suspected improper conduct in all state affairs, and to be accessible to all persons and communities. It provides a platform for us to cement relations and foster collaboration and cooperation between us and other organs of state, including provincial legislatures, government departments, municipalities, and traditional authorities, with a view to promoting quality service delivery and good governance in state affairs. We have already been to 3 provinces, namely Free State, where we interacted with the Speaker, Honorable Sifuba, then Acting Premier, Mr. Dugwana, the Provincial House of Traditional Leaders, and the Mkhwebane Traditional Authority. The Northern Cape, where we met with the Speaker, Honorable Tlaste, Premier Zamani Sol, and his Executive Council, and the KwaZulu-Natal Provincial House of Traditional Leaders. The roadshow has been an eye-opener when it comes to the conditions in which many grassroots communities in those provinces live, from the sewage crisis engulfing Kimberley to the road infrastructure problems that make life difficult for the Mkhwebane community in rainy seasons. This tour of provinces has also presented a platform for us to shine a spotlight on a number of our investigation reports, the implementation of those of whose remedial action remains outstanding, leaving complainants in the lurch, despite the reports having not been reviewed and set aside by a court of law. We are, however, encouraged that the executive in both the Free State and the Northern Cape have undertaken to look into those matters and see to it that justice is done. In the same vein, we are pleased that speakers in the 2 provinces warmed up to our proposition that we are available to present the reports in question to the relevant portfolio committees, where the respondents concerned will have to be invited to account. Tomorrow we will be heading to Northwest to meet the Speaker, Honorable Janki, Premier Mape, and his Executive Council, the House of Traditional Leaders, the Provincial Directors General and heads of departments in Mahikeng. We will then proceed to Nyetse and Riakhile villages outside Zerast in the Ramuchere Moilua local municipality, where we will conduct inspections in local at service delivery problematic areas. We look forward to constructive engagements with the, which will impact positively on service delivery and good governance. The roadshow is scheduled to run until the middle of next month. We now turn to specific reports. Let us start with public housing, an issue we deal with frequently during our briefing sessions. This office has previously conducted a systemic investigation into problems bedeviling the government's housing problem. However, the problems still persist. We urge the government to implement the remedial action in that report in order to stem a recurrence of such complaints. The case the report concerned relates to Mali versus the Eastern Cape Department of Human Settlements and another, which is report 93 of 2021-2022. We investigated alleged failure by the Eastern Cape Department of Human Settlement and the Buffalo City Metropolitan Municipality to provide an RDP house to Mr. El Mali in respect of ERF 7648 in Khayelitsha, Dimbaza. The investigation followed a complaint Ms. Mali lodged in July 2019. In essence, she alleged failure by the Eastern Cape government and BCMM, which is Buffalo City Metropolitan Municipality, to provide an RDP house, which had been approved in 2002, 19 years ago to her. Having studied the complaint, we decided to investigate whether BCMM and the Eastern Cape Department of Housing, of Human Settlement, failed to provide her with the house in terms of the relevant legal prescripts regulating the allocation and occupation of RDP houses, and if yes, whether such conduct amounts to maladministration or improper conduct. We found that indeed the Eastern Cape Department of Human Settlement and BCMM failed to provide Ms. Mali with the house. She had on several occasions visited BCMM requesting that she be provided with the house without success. So the Eastern Cape Department of Human Settlement considered that the house in question belongs to her in terms of the RDP housing subsidy portal, which reflects her as an approved beneficiary. So the department and the municipality have to date not provided her with the house or suitable alternative accommodation, and this resulted to her suffering prejudice. This failure by BCMM and the Department of Human Settlement to enable access and occupation of the said house to Ms. Mali was in contravention of the Constitution and the Housing Act. It accordingly constitutes improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. To remedy such, we have requested that the head of the Eastern Cape Department of Human Settlement must take the appropriate steps to ensure that Ms. Mali is given lawful occupation of an approved RDP house, working in conjunction with the municipality within 180 working days of the date of this report. Apologize in writing to Ms. Mali for the delay in enabling her occupation of the approved house, and further inform her of the steps taken as referred to in this report within 90 working days. The city manager of BCMM must take appropriate steps within BCMM internal policies and in consultation with the Department of Human Settlement to ensure that Ms. Mali, as an approved beneficiary, is assisted and provided with an RDP house. Ensure that internal audit functions of the BCMM conducts regular audits and reviews the adequacy and effectiveness of controls, processes, and procedures on delivery of low-cost housing of the municipality, and report accordingly as contemplated in the Local Government Municipal Finance Management Act. Report to the Council of the municipality on the steps taken to implement the remedial action referred to in this report. Let us now turn our focus to basic education infrastructure. Along with health, education accounts for the largest share of the government budget. However, as a country, we appear to be making slow progress towards ensuring that teaching and learning take place in a conducive environment. The following two reports looking at 2 schools in Limpopo and 2 in KwaZulu-Natal underscore this point. Limpopo Department of Education, we investigated on own initiative the conditions we observed at Kabelo High School and Akhishanang Primary School in Capricorn North District of Limpopo during a visit on the 1st of September 2020. We were at the time conducting inspections in local education facilities to evaluate the conditions and state of readiness of such facilities to respond to the threat that the advent of COVID-19 pandemic posed to teaching and learning. The inspection entailed meetings with the 2 schools' management teams and trade union representatives and interviews with staff members. Having analyzed the available information, we decided to investigate whether Limpopo Department of Education's provision and administration of education services at the 2 schools accorded with the obligations that the Constitution and the law impose, and if not, whether such failure amounts to improper conduct and maladministration. We found that the department's provision and administration of education at both schools does not accord with the obligations imposed by the Constitution and applicable legislation. Observations made during an on-site inspections at Kabelo High on the day as well as on subsequent visits to the facility revealed systemic deficiencies such as inadequate educational tools, inadequate classrooms to cater for social distancing, supply of poor quality PPEs, insufficient ablution facilities, lack of adequate security to safeguard school property, and inadequate scholar transport as detailed in evidence. This failure to provide sufficient secure infrastructure and learning equipment contravenes Section 5A, capital A of the South African Schools Act 1996 and regulations relating to minimum uniform norms and standards for public school infrastructure, particularly Regulation 12, Regulation 14, and Regulation 17. At Akhishanang Primary School, systemic deficiencies such as staff shortages, lack of also adequate educational tools, aging physical infrastructure such as dilapidated buildings and old furniture, insufficient classroom, also insufficient ablution facilities as detailed in the evidence were observed. As in the case of Kabelo High, this failure also violates Section 5 capital A of the South African Schools Act and the regulations in terms of relating to minimum uniform norms and standards for public school infrastructure, particularly regulations 9 and 12. And the department's failure in respect of both schools contravenes Section 195 of the Constitution and Section 237 of the Constitution, and amounts to improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. I must, however, indicate that when we issued a notice in terms of Section 7, subsection 9 of the Public Protector Act, when it was issued to the department, we ended up, we couldn't receive a response, but finally we had a meeting with the MEC and the head of department, leading to consensus on the following remedial action in relate to Kabelo High. Must within 90 working days from the date of this report provide provision for the construction of additional classrooms to meet an increased enrollment of learners, and to prepare the school for any social distancing needs that may arise as a result of possible future revision of disaster management regulations. To ensure and or monitor that schools procure quality face masks for learners that comply with the health standards in terms of the guidelines, and further within 60 working days from date of this report provide a report of all identified schools with specialized equipment and those susceptible to burglaries, as well as an implementation plan of the security measures with the view of fortifying security in those identified schools. Within 90 working days from date of this report provide additional ablution facilities to the school. And in relation to Kabelo High School, the Public Protector takes the following remedial actions. The HOD must also within 90 days of this report construct additional classrooms, also make sure that the schools provide quality face masks, and also identify high schools which have specialized equipments and provide security accordingly. So in relation to Kabelo, we are referring this matter to the South African Police Commissioner of Limpopo in terms of Section 64C, Roman figure 2 of the Public Protector Act, to ensure that Matlala Police Station provides quarterly reports to the Cluster Command and to the Provincial Commissioner's Office on the effectiveness of the school safety program, which has already been implemented at the school. Ensure that Matlala Police Station attends to safety and security related issues at the school, including any criminal incidents, through the assigned police officer or any other officer to which an incident may be reported. In relation to Kabelo, again, we are referring further the matter to the police commissioner, which is a high school in this instance, because the other one is a primary school, so that the very same issues which relates to security and the police commissioner must take care of. The report relating to KwaZulu-Natal Department of Education, report 101 of 2021-2022, the same thing happened. We also visited the schools in KwaZulu-Natal, where we visited Nokweja High School in Iqobo, and Impande High School in Eshowe in KwaZulu-Natal. And these inspections entailed interviewing school principals and management teams. Based on the analysis of the information that came to our attention, observations made at the two schools, we decided also to investigate this matter. In respect of Nokweja High, we found that the department's provision and administration of education does not accord with the obligations imposed by the Constitution and the law. Observations made during the on-site inspection revealed systemic deficiencies, such as staff shortages, lack of adequate teaching and learning equipment, poor physical infrastructure such as severely dilapidated buildings, pit latrine toilets, lack of ICT infrastructure, and lack of adequate desks and chairs in the classroom. Failure to provide sufficient infrastructure and learning equipment as indicated above, violates or contravenes the South African Schools Act and the regulations relating to minimum uniform norms and standards for public school infrastructure, particularly Regulation 10, 11, 12, 13, 14, 16, 17, and 18. The failure by the department accordingly amounts to contravention of the Constitution and constitute improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. Regarding Impande High 2, we found that the department's provision and administration of education does not accord to the obligations imposed by the Constitution and the law, and further the issue we've observed when we visited that there are systemic deficiencies such as staff shortages, lack of adequate teaching and learning equipment, lack of ICT infrastructure, and lack of adequate fencing and security. So this also violates the South African Schools Act and the regulations relating to minimum uniform norms and standards. The failure of the department accordingly amounts to a contravention of the Constitution, which constitute improper conduct and maladministration in terms of the Public Protector Act. We must note that during a second visit to the school on the 15th of February 2022, we observed improved conditions. Guanokweja High School now has 18 educators, comprising 3 males and 15 females. The school also has 12 educator assistants as per the post-provision norm for 2022. At the school, there is no shortage of educators. The learner-teacher ratio is 30 per teacher. So the school has 1 security guard, 3 food handlers, and 2 cleaners and 1 screener. In addition, the school has had general repairs on 3 front school blocks. With regard to Mpande High, the school now has a borehole. It also has an admin intern contracted for 18 months. Further, the school has further contracted 3 educator assistants. So to remedy this, we then also requested that the Department of Education must, within 120 working days, conduct an assessment of the overall schooling infrastructure needs within the province to ensure prioritization of the department's infrastructure budget as advised by Provincial Treasury. Apportion the allocated budget in accordance with the priorities as determined by the assessment envisaged in the remedial action above, and consider prioritizing Nogweja and Impande High School to ensure compliance with the relevant provisions of the South African Schools Act and the regulations relating to minimum uniform norms and standards for public schools infrastructure within 60 working days. Consult with the KwaZulu-Natal Department of Public Works for technical assistance and to ensure alignment of infrastructure priorities of the Department of Education in the province with those of the Department of Public Works, as well as ensure that these 2 schools, Nogweja and Impande High School, are included in the current infrastructure plan. Another regular feature in our briefings is the issue pertaining to the proceedings and payment of public sector employee pension benefits. We have opened a channel of communication with the Government Pensions Administration Agency, which we hope to exploit to address this challenge. Again, learning from our previous reports, officials in government and at the GPA should not be subjecting more people to the kind of hardships of complaint in this next case which this complainant went through. The matter relates to Matlungozi versus the Eastern Cape Provincial Department of Health, and it's report number 92 of 2021-2022. We investigated allegations of undue delay by the Eastern Cape Provincial Department of Health and GPA to process and pay Ms. Matlungozi's pension benefits for the period 5 March 1982 to 30 November 1985. The investigation followed a complaint Ms. Matlungozi lodged in November 2018. Essentially, she alleged undue delay by the department and GPA in processing and paying her pension benefits for the said period. So we focused our investigation on whether the department unduly delayed to submit Matlungozi's amended exit documents to GPA to effect payment of her pension benefits, and if yes, whether the conduct was improper and amounts to maladministration. We also looked into whether JIPA unduly delayed to pay her pension benefits for the period 5 March 1982 to November 1985. We found that the department indeed delayed to submit Ms. Matlungozi's amended exit documents to JIPA. The investigation revealed that Ms. Matlungozi approached the department in July 2018, requesting them to claim the outstanding pension benefits from JIPA without any success. On the 4th of August 2021, the department advised that it had submitted her amended exit documents, namely Z102 and Z125 forms, to JIPA. However, JIPA rejected the documents, contending that there was no proof of pension contribution for the period in dispute. The undue delay on the part of the department was in violation of the Constitution and Principle 7 of the Batupili Principle. Accordingly, the conduct of the department constitute improper conduct in terms of the Constitution and maladministration in terms of the Public Protector Act, and it prejudices Ms. Matlungozi. We also found that JIPA did delay to pay Ms. Matlungozi's pension benefits for March 1982 to November 1985. Based on the evidence at hand, namely available from State Information Agency SITA, the printouts or cash book records, JIPA's membership certificate was provided to her, indicating that indeed her pensionable service period commenced on the 5th of March 1982, and the weight of this case log discussed in the report, Ms. Matlungozi has produced sufficient evidence to conclude on a balance of probabilities that she was a contributing member of the Siskai Civil Servant Pension Fund from 1982. She also confirmed, as per affidavit, that she never claimed her pension benefits when she left her first employer, Nompumelelo Hospital, in 1985. In the case of Mileng, it was clearly found that to expect a complainant to obtain proof from an employer that is no longer even in existence for a period dating back more than 30 years, in circumstances where it is not clear if accurate or correct service records were kept during the country's transitional period in the first place, is to demand the impossible. In addition, the approach by JIPA to shift the responsibility to provide documentary proof onto the complainant and the employer department when it failed to ensure the accuracy of its own internal records during the integration process is not only unfair and therefore improper, but also constitute dereliction of their statutory or constitutional responsibilities, as observed by the court in Hangana matter. The evidence obtained during the investigation indicates that the department could not trace Ms. Matlungozi's original file, but managed to retrieve the records from SITA archives, and JIPA rejected them. The conduct of JIPA was in violation of the Constitution, GEP law, and principle of Batupili principles. Therefore, JIPA's conduct constitutes improper conduct in terms of the Constitution and maladministration in terms of the Public Protector Act. To remedy this improper conduct and maladministration, the department's HOD must, within 30 working days from date of issue of this report, apologize in writing to Ms. Matlungozi for the undue delay to process the amendment of the Z102 and the Z125 pension forms for the period in dispute as envisaged in Principle 7 of the Batupili Principles. In addition, the HOD must, within 30 working days from date of this report, commence the process of resubmitting Ms. Matlungozi's amended records to JIPA in line with the reasoning of the court in both Mileng and Hangana court cases referred to above and the GEP law. The CEO of JIPA, on the other hand, must, within 60 working days from date of this report, commence the process of recognizing and effecting the necessary changes in respect of Ms. Matlungozi. This issue of how and where municipal funds, in fact, there's the other report which we've issued. I think we are done with this one. So the next one is relating to the issue of how and where municipal funds are invested, became a big talking point at the height of the VBS scandal. The next case is different but falls within the broader question of irregularities when it comes to investing public funds, especially the local sphere of government. The matter is Delil versus George Local Municipality, Report 94 of 2021-2022. We investigated allegations of improper conduct and maladministration by the George Local Municipality with regard to the alleged irregular investment of public funds in the amount of 350 million with Old Mutual Limited during 2017. The investigation resulted from a complaint lodged in April 2019 by Ms. Delil, the MP, the Minister of Public Works and Infrastructure, in her capacity as the leader of the Good Party. A preliminary investigation was conducted in terms of Section 7(1) of the Public Protector Act for the purpose of determining the merits of the complaint and the manner in which the matter should be dealt with. This was because the information submitted along with the complaint indicated that the former municipal manager, Mr. Trevor Botha, had reported the allegations of financial misconduct pertaining to the Portfolio Council for Financial Services Councillor, Dr. D.L. Gronje, the municipality's former CFO, Mr. Keith Jordan, in respect of certain investment with Old Mutual and the South African Local Police Services Directorate. So Mr. Botha reported this matter to the DPCI. He had also reported the matter to the Western Cape Minister of Local Government, Environmental Affairs and Development Planning, Mr. Bredel, the head of the Department of the Western Cape Provincial Treasury, and the Director General of Treasury, National Treasury, and the Executive Mayor of the municipality. So DPCI and the NPA advised that charges of fraud and corruption were proffered against the former CFO, Councillor Gronje, and his son, Mr. Gronje Jr., and that the NPA had declined to prosecute the matter in 2020-2021. The MEC advised that the former CFO, Mr. Jordan, was dismissed following a disciplinary hearing in connection with the matter and vacated his office 8 July 2019, and that the council appointed a special committee to investigate and make a finding on the alleged breach of the code of conduct for councillors by Councillor Gronje. In addition, the municipality advised that the municipal council had resolved on the 25th of March 2021 that Councillor Gronje, well, they quoted in their records, made himself guilty of the breach of item 2 and 5 subsection 2 of the Code of Conduct for Councillors, and the council imposes a sanction of a fine equivalent to 1 month's salary on Councillor Gronje, along with a written apology to be provided to the Speaker. In light of the above, the investigation focused on allegations that in July 2017, the municipality entered into an agreement with Old Mutual, giving rise to the irregular investment of initial amount of 200 million of public funds with a financial services company, and subsequently investment in November 2017 of a further 150 million with the company. So the investigation, so in total, is 350 million. The investigation specifically focused on the alleged contravention of the Municipal Finance Management Act, the Municipal Investment Regulations, and cash and investment policy of the municipality caused by the investment transaction the municipality concluded with Old Mutual. Accordingly, the issue we identified for investigation were whether the municipality irregularly invested public funds with Old Mutual. So we found that the municipality did invest municipal funds with the Old Mutual irregularly. The investment were in violation of Section 13(1) of the Local Government Municipal Finance Management Act, the Municipal Investment Regulations, and the cash and investment policy of the municipality. So the conduct was improper as envisaged in the Constitution, and it was maladministration per the Public Protector Act. We further found that the municipality's systems, processes, internal control measures, and checks and balances governing its investment of public funds were not entirely efficient and provided inadequate checks and balances to prevent the improper investment of municipal funds. So therefore, the internal control mechanisms and checks and balances provided for in the Local Government Municipal Systems Act, MFMA, and the relevant regulations and the investment policy were either deficient or, if available, were not effectively applied. So the effectiveness of the investment policy is dependent on the accuracy and integrity of a municipal's cash management program, which must identify the amount surplus of the municipality's needs, as well as the time when and period for which such revenues are surplus. So the conduct of the municipality accordingly constitutes improper conduct, and to remedy this maladministration and improper conduct, the municipal manager must evaluate and identify what were the main deficiencies in the municipality's investment policy and procedure, its internal financial controls and risk management policies and procedures, which made the irregular investment possible, and then take steps to address this. Take disciplinary action against the municipal officials who were implicated in non-compliance with the municipal policies. Engage the Financial Sector Conduct Authority to assist with the identification of the deficiencies and assist with training of the relevant municipal officials and councillors responsible for oversight regarding municipal investments. Ensure that the municipality's administrative units and processes are capacitated to detect and prevent gaps and threats in regard to municipalities' investments transaction involving internal and external parties. Ensure that investments by municipality are concluded as a risk in the operational and strategic risk register of the municipality. Report to the council on a quarterly basis on the status of investments made or to be made by the municipality. Ensure that the internal audit unit of the municipality conducts regular audits and reviews the adequacy and effectiveness of the controls, processes, and procedures on the investment account of the municipality and report accordingly. And the executive mayor, on the other hand, must take appropriate steps to ensure that the audit committee of the municipality is properly constituted as contemplated in section 166 of the MFMA, with members that are competent and that they have the necessary skills, qualifications, and experience to perform their statutory responsibility. So going around the provinces as part of the roadshow, one of the issues we have been bringing to the attention of authorities is the problem of irregular appointment of staff and the frequency of complaints about the issue. The next report deals with such. This relates to Mdluli versus the Department of Correctional Services. It's report 100, 2021-2022. We investigated allegations of improper conduct and maladministration by functionaries of the Department of Correctional Services relating to the appointment of Mr. Sihle Zigalala, not to be confused with the Premier of KZN, in the post of Deputy Commissioner, Intergovernmental Relations in June 2018. The investigation followed a complaint by Ms. Busisiwe Mkhwebane, which was lodged in December 2019. Ms. Mkhwebane alleged that the department advertised the post of Deputy Commissioner Intergovernmental Relations, inviting applicants to submit applications before the closing date, which was 24 February 2017. The requirements of the advertised post were, among others, that the applicant should be in possession of the undergraduate qualification NQF level 7 in public management or equivalent, as well as 5 years experience at a senior management level in a similar environment. She further alleged that Mr. Zigalala was appointed in the post of Deputy Commissioner Intergovernmental Relations with effect from June 2018, despite him not having 5 years experience at senior management level in a similar environment. Our investigation focused on whether Mr. Zigalala was appointed in the post of Deputy Commissioner without him having 5 years experience at a senior management level in a similar environment. If so, whether such conduct amounts to improper conduct and maladministration. We found that indeed Mr. Zigalala was appointed to the post of Deputy Commissioner without having 5 years experience at senior management level. So at the time of submitting his application of the position, Mr. Zigalala had 3 years and 2 months experience at senior management level. The shortlisting and interviewing panel and the executive authority disregarded the minimum number of years of experience required as stipulated in the advertisement for the post, which favored the shortlisting of Mr. Zigalala. So the shortlisting and interviewing panel failed to promote the basic values and principles governing the public administration as required in Section 195 of the Constitution, which obliges state organs to, amongst others, uphold and maintain high standard of professional ethics, engage in employment and personal practices based on ability, objectivity, fairness, and render services impartially, fairly, and equitably, and without bias. So in this instance, the executive authority did not satisfy himself to conformity with Regulation 67(9) of the Public Service Regulations that Mr. Zikalala qualifies in all aspects for the post of Deputy Commissioner. The conduct of the shortlisting and interviewing panel and the executive authority rendered the appointment of Mr. Zikalala in the post irregular. In this regard, the conduct of the shortlisting and interviewing panel and the conduct of the executive authority constitute improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. To remedy this improper conduct and maladministration, the Minister of Justice and Correctional Services must, within a reasonable time but not later than 90 working days of receiving this report, take action to address the irregular appointment of Mr. Zikalala in the post of Deputy Commissioner in conformity with the Public Service Act, or take any other steps provided in the Labor Relations Act 66 of 1995. The National Commissioner of the Department of Correctional Services, on the other hand, must, within 90 working days of receiving this report, take disciplinary action in terms of the Public Service Act and regulations against the shortlisting and interviewing panel members for breaching the code of conduct of the public service relating to shortlisting, interviewing, recommending appointment of a candidate who did not meet all the inherent requirements of the post of Deputy Commissioner. The next matter relates to Gilfillan versus the Department of Sports, Arts and Culture, Report 95 of 2021-2022. We investigated allegations of maladministration and improper conduct in connection with the appointment of private law firms by the Department of Sport, Arts and Culture for litigation in which the department was not a party, as well as failure by the department to take appropriate action against those responsible following allegations of financial misconduct by the Culture and Creative Industries Federation of South Africa. 2 complaints were lodged by Mr. Gilfillan and Mr. Mthethwa in September 2018 and 2019 respectively, which gave rise to this investigation. Mr. Gilfillan alleged that the department contravened the PFMA, National Treasury Regulations, and State Attorneys Act. According to him, the department entered into agreements with various private law firms, including but not limited to Mr. Edward Nathan Sonnenbergs Incorporated, Spoor and Fisher Attorneys, L&M Attorneys, at the exclusion of the state attorneys between 2009 and 2018. It allegedly did so with specific mandate to, among other things, ensure the removal of the 2 existing trustees, which is Mr. Gilfillan and Mr. Dumisani Mota of ZM Makeba Trust, which oversees Mr. Makeba's affairs and appointed by Ms. Makeba, and oversee the department's reclaiming of Ms. Makeba's legacy from third parties. So Mr. Gilfillan also alleged that the department incurred irregular, frivolous and wasteful expenditure by making direct payments to private law firms and other intermediaries for the implementation of the above agreement, and in so doing breached the Culture Promotion Act, which is CPA. Mr. Eugene Mthethwa, on the other hand, based his complaint on media reports dated July 2019, published in the City Press that under the headline, "The 100 Million Arts Funding Scandal." According to the article, the department allocated 36 million over a period of 3 years to Ladysmith Belk Mambazo for the purpose of teaching traditional Zulu and dance, and to record an album with the former president of South Africa, Mr. Jacob Zuma. This amount, according to the article, was among the questionable funding deals, amounting to 100 million to have been spent by the department led by Minister Mthethwa for the period 2018-2019 funding period. It was also reported that in the article, Further funding allocations, which senior officials in the department claimed were questionable, included 50 million paid to the National Empowerment Fund without the required committee approvals, 20 million over a period of 2 years assigned to the Indoni South Africa Cultural Organization, 12 million for the Usiba Cultural Awards Show, 10 million to the Living Legends Trust Fund, and another 3 million which the department allocated to private lawyers. Mr. Eugene Mthethwa alleged that CCIFSA, a non-profit company set up with the assistance of and funded by the department to promote and develop the social and economic interests of the cultural and creative industries and to act as controlling body for these sectors, misappropriated public funds in connection with the hosting of Usiba Creative and Cultural Industries Awards and the Downtown Music Hub. It is the contention of Mr. Mthethwa that the conduct of CCIFSA and the department constitute fruitless and wasteful expenditure. Having analyzed the two complaints, we decided to investigate whether the department contravened the provisions of the PFMA and the Cultural Promotions Act by providing funding for litigation in which it was not a party, and if so, whether that constitutes maladministration and improper conduct. We also investigated whether the department failed to take appropriate action against CCIFSA following allegations of financial misconduct. Our investigation confirmed that the department contravened the provisions of the PFMA, National Treasury Regulations, and CPA by providing funding for litigation in which it was not a party. In terms of Section 2(1)(a), Roman figure 4 of the CPA, the Minister of Arts and Culture may, in order to develop and promote arts and culture of the Republic, establish, launch, or finance any organization or project whose objects are likely to have an impact throughout the country. Irregular expenditure is defined in the PFMA: expenditure other than unauthorized expenditure incurred in contravention of or that is not in accordance with the requirement of any applicable legislation. So the interpretation of Section 2(1)(a)(4) Roman figure 4 of CPA by the department to include the provision of funding for litigation in which it was not a party, in particular in the removal of the trustees of the trust, is misdirected on the basis that the removal of the trustees does not in any way advance the development nor promotion of arts and culture in the Republic, and object thereof have no impact throughout the country. It is evident that the funding provided to the beneficiaries of the trust and the foundation by the department was defrayed out of monies appropriated by Parliament. Notwithstanding the above, the funds were utilized for litigation for the removal of the two trustees of the trust as opposed to the development and promotion of arts and culture in the Republic, the establishment, launching, financing, and organization of all projects whose objects were likely to have an impact throughout the country. Therefore, the department's conduct was not in line with the objects of Section 2(1)(a), Roman figure 4 of CPA, especially the requirement of providing funding to any organization or project whose objects are likely to have an impact throughout the country. In terms of Section 64, subsection 1 and 64, subsection 3 of the PFMA, any directive by any executive authority of a department to the accounting officer of the department having financial implications for the department must be in writing, and a copy of this document must be filed with National Treasury and the Auditor General. The only evidence submitted by the department is a memorandum containing a note purporting to be in the minister's handwriting, where the minister asserted that he was not sure whether 500,000 was not over the top, and requested a further motivation, ostensibly as an admission that he was aware of the assistance sought by the beneficiaries of the trust and the foundation. The failure by the department to ensure that the directive to utilize funding defrayed from monies appropriated by Parliament was reduced to writing was not in accordance with the principles referred to above, especially the requirements that the directive must be in writing and filed by the DG with National Treasury and AGSA, respectively. In the circumstances, we found that the allocation of funds to the Trust and Foundation for litigation in which the department was not a party, as well as the failure to ensure that the directive for the utilization of funds were in writing, constituted irregular expenditure and therefore equated to improper conduct as envisaged by the Constitution and maladministration as envisaged by the Public Protector Act. We did not investigate any other allegation that the department failed to take appropriate action following allegations of financial misconduct by CCIFSA for the following reasons. In terms of the Constitution, the Public Protector is mandated to investigate any conduct in state affairs or in public administration or any sphere of government that is alleged or suspected to be improper or result in impropriety, prejudice, and to report on that conduct. The evidence received during the investigations indicate that CCFISA is a non-governmental organization comprising of practitioners and activities in the sector that speak to the department's mandate and not an organ of state. Therefore, its conduct does not amount to improper conduct in state affairs. Notwithstanding the above, it was noted that the department has since appointed a company called Big Business Innovations Group to assist with the investigation into allegations made, as well as auditing CCIFSA since its establishment, and the process is underway. Therefore, the allegations by Mr. Mtoto that the department failed to take appropriate steps following allegations of financial misconduct by CCIFSA has no merit. The appropriate remedial actions we are taking in this matter, the Minister of Sport, Arts and Culture, Mr. Natim Tetwa, to take up cognizance of the findings on the acts of maladministration, improper conduct and irregular expenditure by the DG envisaged in the PFMA referred to above. Ensure that in future all ministerial directives having financial implications for the department are reduced to writing, and the DG files same with National Treasury and Auditor General. Include in his executive oversight role over the department the monitoring of implementation of remedial action taken in pursuit of the findings in terms of the powers conferred under the Constitution. The Director General of Arts and Culture, too, in line with PFMA, ensure that appropriate actions are taken to ensure that such conduct is not repeated and prevent the recurrence of the improprieties identified in the investigation. Ensure that the finalization of the forensic report conducted by BIG into allegation of misappropriation of funds by the CCIFSA, the Public Protector is provided with a copy of the final report. Ensure that prior to approving requests for funding from third parties, in terms of the CPA, such requests are subjected to a comprehensive legal vetting by the department's legal section with a view to ensure that they comply with the provisions of the Act, and that same is for the purposes intended by the relevant provision of the CPA. Ensure that the particulars of the irregular expenditure in the final report is immediately reported in writing to National Treasury as envisaged in the PFMA. Ensure that the irregular expenditure is included in the department's report on revenue and expenditure submitted by the accounting officer to National Treasury in terms of the PFMA. Simultaneously, request for condonation for non-compliance with the PFMA and the CPA, respectively, and implement compliance checklists to supplement policies and procedures available to the department. And in line with PFMA, ensure that appropriate disciplinary steps are taken against any officials of the department who may be found to have been involved in the financial irregularities referred to in the report. The department's Director of Human Resource Management to ensure that line managers, divisional managers, and senior managers are well capacitated to understand their role to improve the department's governance and financial management through implementing effective internal controls in their respective areas. We look forward to the full implementation of remedial action in all of these reports Where there are questions in relation to findings and remedial action, our doors are always open to engage. This has proven effective and can save the state a lot of money in that unnecessary litigation can be avoided. One of the messages we have been preaching on the roadshow is that this institution is not the enemy of government. Through our inquisitorial and not adversarial processes, we work together with government to ensure that our common goal of ensuring quality public service delivery and good governance is realized. Thank you.
Thank you, Public Protector. I will now open the floor for questions. I will request those colleagues who would like to pose questions to the panel to first introduce themselves and then put their questions to the panel. We have invited those colleagues who are joining us online to text their questions to us. That's why we haven't received any. Let me check in the room if the colleagues who are here with us would like to pose any questions at all to the panel. It does not look like the colleagues want to pose any. Oh, there's one from.
And I'm not going to ask something on the report, and so I'll wait for my colleagues to ask. Public Protector, if you can allow me, I'm just going to ask you a question in regards to some of the other complaints you have received. I know that you have received a complaint from Mervyn Dirks in regards to the President and that leaked audio clip. I just want to find out how far is your investigation with that matter, and will the conduct of some of the MPs when it's got to do with the handling of SCOPA also form part of your investigation? Thank you, Mbali Chatani from Mr. Matlungozi.
Thank you, Mbali. It seems like that's the only question we have at this point in time. May respond to them.
Okay, Mbali, the investigation is ongoing. That's all I can say for now. I remember I also said, yes, the investigation was lodged in terms of the Executive Members Ethics Act, which obliges the Public Protector to investigate. I don't have any discretion not to investigate that matter, but then it doesn't seem to be, we will be in a position to finalize the investigation within 30 working days as required by the Act. So we will inform the Speaker of the National Assembly, because the Executive Members Ethics Act is not clear where should we report when we can't finalize the matter within 30 working days. And we only focus on the conduct of the executive, and we will not be investigating any conduct of members of parliament, because we don't have jurisdiction over members of parliament. Thank you.
Do you have an indication as to how long? I know you said that you should have been replaced, but do you have an indication in terms of how long this matter will take?
For now, I wouldn't be able to say, because we're still collating evidence, we're still requesting affidavits, and also investigating on our own or independently to determine the whether the investigation will proceed and how it will proceed. So I wouldn't say by when.
Thank you, VP. Any further questions from the floor? There's still nothing coming from the online platforms. In the absence of further questions, I will then proceed to adjourn the briefing session. I'm not sure if the colleagues here want any one-on-ones. Okay. Thank you so much. Thank you so much for coming through.
Thank you. Thank you, thank you.
Oh, for the full copies of the report, they are being uploaded on the website now. So you can just go to the website to obtain the copy.
Thank you, thank you.
Thank you, Fifi. I'm sure it's an amazing.
Can we correct that? There's a reporting.
NTI.
There's a reporting for each one. No, statement.
Oh.
Okay.
All right.
Are you still in need of a lift, or are you going with this person?
When is he leaving?
Come on, sit with him. Come on.